Right, good morning, everybody. This fine Thursday morning and part of the Freedom Day week. I'd like to thank you all for joining us for this session on the POPIA Act and competition law compliance. As you'll note on the screen, the meeting is being recorded, and by participating, you give consent thereto or thereof. And just competition law reminder and conflict of interest, the meeting is held with no intent to collude or engage in any matter that might contravene competition law. Conflicts of interest must be declared, and if required, members recuse themselves either before or during the meeting as and when they become apparent. And that statement in terms of competition law is one that is made at every meeting of SAMED, irrespective of board meetings, subcommittee meetings, etc. My name is Rob Miller. I'm a board member of SAMED and the chairperson of the SAMED Code Standing Committee. And as I said, I'd like to welcome you all here this morning. Before we start, just a few housekeeping points. It is a Teams meeting. We ask that you keep your video turned off unless you're speaking and wish to be seen. That's just to assist with the bandwidth. And that you keep yourself on mute, please. It's quite important because it can be quite disruptive. Just ensure that you are on mute, and you may, in due course, when we call on you, you may want to unmute and talk. If you want to ask any questions, use the chat facilities if you wish. You see at the top, there's the little icons. From the left is the members, the chat facility, and then there's also the raise your hand and I'll call on you to speak. We'll monitor all the questions and what have you and address them at the end of each presentation. We have with us this morning, in terms of speaking to us about the POPIA Act or POPIA for medtech suppliers, Esme Prince van den Berg. And we're going to look at the protection of personal information, the POPIA, which members have to implement within their companies. And if I speak under correction, but I think the Act comes into effect at the end of June, and Esme will enlighten us on that. Esme will take us through the Act, the requirements for considerations for our sector. Esme is a qualified attorney specializing in law, including the POPIA Act and the Consumer Protection Act, corporate governance, health policy, and health industry matters. Esme was also instrumental in guiding SAMED itself through the process of being compliant with the POPIA Act, or getting ourselves compliant, and I must say produced quite a formidable document. And I think one needs to be aware that POPIA, or the Act, is quite onerous in terms of what companies need to do with personal information. So without any further ado, I'd like to hand over to Esme, and thanks for joining us this morning, Esme.
Good morning, Rob. Good morning, ladies and gentlemen. Thank you for this opportunity. I just want to get my screen shared. Can somebody just give me an indication if you can see the screen?
Yes, we can see you.
Thank you very much. Yes, I will switch off the video for now, and when we do questions, I'll switch it on again. Thank you for this opportunity. I think the way I want to plan this today is not to take you through the Act. I'm sure you've seen a lot of this before, you know most of this, but to actually just give you a few pointers, a few reminders on things that we should look at now, a few new developments, which I think you should be aware of. I've received a few questions in advance that I want to address. If we have time, I will share a few case studies with you from Europe to just indicate to you what are the things that the regulators are actually concentrating on. But if time doesn't allow for that, you can obviously go through the case studies on your own when you do receive the presentation. So I will talk about the status then. I want to talk about new regulations that were published on Friday, very important regulations for us. The guidance notes that were issued by the regulator recently, a few general reminders about the law. And as I've mentioned, if we have time, the case studies. I will give you a few steps that you need to consider to become POPI compliant if you aren't compliant yet. I will deal with the questions. If we have time, we'll do a few fun questions in terms of a quiz, and I will then conclude so that I have time for questions and answers. The acronyms is just to help you when you refer back to my presentation. So in terms of the status of POPI, POPI is actually law as we speak. It was fully implemented last year on the 1st of July in terms of the provisions becoming law, but the enforcement of the provisions will only start on the 1st of July this year, roughly 2 months from now. There are still a few provisions that will be implemented, but not in POPI. Those provisions relate to other laws that are affected by POPI. So, for example, the POPIA law, the Promotion of Access to Information Act. This act is currently administered by the South African Human Rights Commission, and it will actually move across to the jurisdiction of the information regulator on the 30th of June, and certain amendments will take place in this act and on that date. All the POPI regulations have not been implemented. We have staggered implementation. On the 1st of May, for example, the regulations relating to information officers become implemented, and on the 1st of July, all the regulations will be implemented. There is no general exemption or exclusion for any medtech supplier under the POPI Act, so you have to comply with the entire Act. There is a provision for codes of conduct to be issued, but there is no code of conduct in place for the healthcare industry or for medtech suppliers, and no code has been proposed either. There's only been one draft code proposed that's open for comment, and it doesn't affect us in the healthcare industry at all. It's for the credit bureaus. I've given you also the website address if you want to access all the different documents that I'm talking about this morning. First of all, the POPI Act and the regulations. The POPIA Act is also on this website of the information regulator. And then all the guidance notes that have been published by the regulator to date. First of all, relating to codes of conduct, then prior authorization, and thirdly, information officers. I will deal with the last two guidance notes in the presentation. I will not deal with codes of conduct because it's only relevant if you are interested in proposing a code for the industry, which I do not believe is on the agenda at the moment. Another important issue that I want to bring to your attention is the publication of the draft regulations in terms of POPIA, the Promotion of Access to Information Act. These regulations were published last Friday on the 23rd, and the comment deadline is the 17th of May. Now, the main purpose of these regulations is to bring it in line with POPI. But there are a few regulations that are of great concern, and I'll point them out to you now. And I actually expect these regulations to be finalized by the 1st of July. So we might actually, close to implementation date, find additional requirements with which we have to comply. And let me point out to you what is my major concern with these regulations. So first of all, they bring in information officers of private bodies under this law. They create additional requirements for information officers related to a POPIA manual. Now, a POPIA manual is a requirement under POPIA and under POPI for your company or entity. So the proposal is now that everybody that has a POPIA manual must actually have that manual in all the official languages of South Africa on the company or entity's website. And secondly, you have to have the the document in 2 official languages at your office. Now, this is a huge requirement, very concerning in terms of the cost and the implications, especially for the smaller businesses. And you can just imagine for medical practices, it will apply to everybody when it's implemented. So this is of concern, and if you are intending to make comment, I would suggest that you do consider submitting a comment on this. Other issues that one should take note of. So currently, under POPIA, there's a Form C that if a person wants to request access to their records at your business, or at your company, they have to complete Form C. So they are proposing a new form in the draft regulations. It will become Form 2. It's a more streamlined, up-to-date version. So there will be a new form in all likelihood. It also requires information officers to assist requesters who can't complete the form, to complete it, to assist them with completion. And if you make a decision on a request, Form 2, you actually have to record your decision using another form, Form 3, which is also proposed. There are also new fees prescribed in terms of what you can charge, and it creates an offense for the information officer if any other fees were to be charged. So this is not law yet, but as I've mentioned to you, it will probably become law in whatever form by or before the 1st of July this year. It's now out for comment, and you must keep your eyes on this, and if possible, even submit comment to this document. I then want to touch on the 2 guidance notes that have been issued recently by the information regulator. The first guidance note relates to prior authorization. I just want to remind you what this is all about. So what POPIA says is, if you do certain types of processing, you have to notify the regulator about that processing and obtain prior authorization from the regulator. Now, at the moment, there are 4 types of processing that can fall under this particular provision of POPIA. So the first one is where you process unique identifiers. So, for example, let's say you've got a customer number, you allocate customer numbers to your customers, that's a unique identifier. But now you want to process it for a different purpose than for what you've originally allocated that number to your customer, and you link it to information from other responsible parties. So there are 2 conditions before you fall under this particular category. Because often we all have unique identifiers, let's say for a customer or a client or a service provider, but it's only if you process that unique identifier for another purpose than the original intention, and you link it with information from other responsible parties, then you fall under this section. Also, when you do credit reporting, it's, for example, when a credit report is actually prepared to look at the credit worthiness of a particular data subject. The third option is where you actually process criminal behavior or unlawful or objectionable conduct on behalf of third parties. And the fourth option is where you transfer special personal information, like health information is a special type of information, or the information of children to a third party in a foreign country, and that foreign country does not have adequate protection of personal information. So in my view is that probably only the last option, the 4th category, could be relevant to your business. The question is then, when is it applicable? Which countries do not have adequate protection? At the moment, we don't have a list of those countries. The information regulator has indicated that they will also issue a guidance note on these kind of transfers of information across the borders. So if you're on this slide, and you have to notify the regulator. There is now a form that has been prescribed for the notifications, and it's part of the guidance note. Prior authorization from the regulator will be either explicit or implicit. So the regulator could give you a definitive answer to say yes or no, or say you must do your processing subject to conditions, or it could be implicit. There are certain time periods prescribed, and once those time periods have lapsed and the regulator has not responded to you directly, you would be able to assume that you can continue with that processing. You can now, when you notify, you don't have to stop processing when you've notified the regulator as prescribed. However, from the 1st of July, once you notify, you have to stop the processing until you've heard from the regulator or the processes or the time periods have lapsed. And when you do not notify, if you do any of these processing activities and you do not notify the regulator, it's an automatic offense, which means that you can incur an administrative penalty, which is quite significant. So this is an important thing to consider in your business. The next aspect relates to the guidance note that was issued about information officers. And essentially, every public and private body must have an information officer. If you look at a private body, it's essentially the head of the private body. If you're a natural person, it's yourself. If you're a human being, only in your personal capacity you run the business. You can also authorize another person. If you're conducting a partnership, it's one of the partners or another authorized person. Or if it's a heuristic person like a company, many of you are structured as companies, it would be your chief executive officer, an equivalent person, or another authorized person. The law also makes provision for the appointment of deputy information officers. Now, certain entities must have deputy information officers. And for example, it's explicitly been determined by the information regulator that a multinational must have an information officer and a deputy information officer in South Africa. The information officer must be registered with the information regulator. The process is already open, so there is a prescribed form that you can complete and submit via email, for example, or alternatively, you can wait for the online portal to open. It's expected to open on the 1st of May, but it might also be a little bit later. The regulator will guide us in this, and you have to register your officer before the 1st of July. Essentially, your information officer can't assume office without being registered, but it depends now how long the registration process will actually take. The position of information officer is extremely important, and under the POPIA Act, there could be action taken against an information officer who is not discharging his or her duties. So it's really a very important position. There are a number of statutory responsibilities imposed on the information officer. These are the following: that you must ensure that there's a personal information impact assessment done. You must encourage and ensure compliance with the law. You must deal with any requests that are submitted to your company under POPIA. If there are, for example, investigations or requests coming from the regulator, you have to work with the regulator or respond to requests. You have to develop a compliance framework. So you must develop this framework, you must implement, monitor, and maintain it. You have to make sure that the POPIA manual is developed, and you must provide it as required in the law and maintain it. You must have an internal process to respond to requests for access. Now, POPIA describes that for us, and this is where the POPIA law comes in as well. And the information officer guidance indicates to us that you must actually keep a record of the number of requests that you do receive, because annually the regulator can ask information officers to submit statistics on the number and type of requests that you actually have received in your company. And then lastly, from a statutory point of view, you are responsible for training and awareness within your company. Within the company, you can also impose other functions and duties on the information officers. And as I've pointed out to you earlier, there are also additional duties imposed now or proposed to be introduced for information officers in the draft regulations under POPIA. Then I want to just do a few general reminders to you about the law without going into too much detail. This is an introduction also to the questions that I have received. First of all, to remind you of what is processing, what does it mean? And processing is not conclusively defined in the law, but it's anything essentially that you can do with information. When you collect information, when you receive it, somebody sends you information. You're actually processing it. When you're storing that information, you are processing it. When you're using it, you're disseminating it, you're destroying it, you are actually processing that information. And one needs to think about your activities in the broadest sense. Similarly, if you think about personal information, we're talking about information relating to an identifiable, living, natural person. So a human being that's alive, and an existing heuristic person or a legal person like a company. Most of the regulators are also heuristic persons. So all of these entities have personal information, and personal information is essentially everything about that particular data subject, being the human being or the company or the regulator. Individuals, it could be things like age or gender or health status, medical history, identity numbers, your unique identifiers, biometric information, personal preferences, for example. So it's again not conclusively defined, and it's any information that you have within your business. So all the processing of the information must comply with 8 conditions. There are a few other requirements in POPIA as well, but just as a summary, in terms of the conditions, accountability lies with the responsible party, generally the company itself. Some of the companies are also operators for the European parents, but generally the companies would be responsible parties in South Africa. The second condition, the processing limitation, says you may only process information on a lawful basis that's defined in POPIA. So you must look at those lawful bases and determine whether your processing is lawful. It also restricts from where you can collect information. I will talk about that now shortly. And it also says you must only collect and process information that you need, the minimality principle. Don't just collect information because you may or you can. Condition 3, the purpose specification. So when you collect information and when you process information, you must define the purposes for which you do that, and it needs to be communicated to your data subjects and also in your POPIA manual. Condition 4, the further processing limitation, says if you have information, you've collected it, you've processed that, now you want to use it for another purpose. It doesn't mean because you have the information, you can use it for another purpose. This further purpose for which you want to use the information must be compatible with your original purpose. And if it's not, you can't process the information for that particular purpose. Condition 5 relates to information quality, so that you must make sure that your information is accurate and correct that you process. Condition 6, the openness, specifies information that you need to communicate to all your data subjects. And I will come to that also again shortly. And it contains the conditions or the requirements for POPIA manuals. Condition 7 deals with security safeguards. where you have to do an assessment of your security processes and technology. So it's systems and its processes within the organization. And there are certain prescriptions around that, and you have to update that, do risk assessment, and implement mitigation controls. This condition also deals with operator requirements, or the European equivalent is a data processor. So if you act as an operator or a data processor for somebody, or you have a service provider that's a data processor or an operator for your business, there are certain requirements that the contracts between the parties must meet under this condition. It also requires you that any privacy breach must actually be reported to the information regulator and the data subject that's involved. And the last condition, the data subject participation, deals with data subjects' rights to have access to the information in your possession and under your control, that they can come and ask you for copies of that, they can come and ask you for corrections to that information or deletions to that information. And just to also mention, the purpose specification under condition 3 deals also with record keeping requirements, which I will also deal with. So that's just in a nutshell the 8 conditions. So let's look at the record keeping principle. In Europe, they talk about the right to be forgotten, which is actually explaining this quite nicely. And it essentially says, you may not keep information forever because the data subject has the right to be forgotten. So we talk about it as record keeping in POPI. So the principle in POPI is you keep information for as long as it's necessary to achieve the purpose of collection and processing. And if you don't need that any longer, then you must destroy the information or the records, delete it or de-identify it. So that is the principle. However, POPI gives us other options as well. So you can keep information for longer periods if you can justify it on one of the 6 other grounds that POPI provide us. The first one is, for example, a law, like the Medicines Act or the regulations in the Medicines Act that stipulate how long you must actually keep records, for example, from around in respect of your Class D implantable medical devices and the high-risk custom-made devices, where the manufacturer, distributor, or wholesaler must keep it for 50 years. So then that's what the law says. You can also keep information longer for a lawful purpose. Then you must identify that lawful purpose. For example, if there's a recall, there could be a contract between you and a particular service provider that specifies how long you must actually keep the information. You could have consent, for example, from a patient of how long you must keep their information or could keep their information. You can keep it longer if you want to use it for historical, statistical, or research purposes, and then you have to make sure that there are appropriate safeguards in place to protect that information, that you don't use it for another purpose. And lastly, if you have used a record to make a decision about a data subject, you can keep it longer as specified in a law or a code. Now, we don't have a code at the moment. Otherwise, you keep it for a period that would allow the data subject to come and ask you for access to that particular record. So that will depend on the type of data subject and the type of record. So you can see there are multiple options. So when you decide on how long you keep information, you need to go through the process and decide which basis is actually applicable, which ground, and actually support your keeping of a particular record. And I advise that you do have a record keeping policy in place. I also want to mention collection of personal information. So POPI says when you collect information, your source of collection, the principle is you collect it from the data subject, like the healthcare practitioner or the patient. But POPI actually also says that you can collect it from other sources and give you 6 options again. So you can collect, it's acceptable to collect information from a public record or where information was made public by a data subject, if you have consent of that data subject, and then grounds 3 and 4 deals with legitimate interest. So it essentially says if there's no prejudice to a legitimate interest of the data subject, you can collect from another source, or if you want to maintain your own legitimate interest. Now, the only thing that you must know is when you use legitimate interest as a ground, there could be an objection lodged by the data subject to say, but you can't use it for that on that basis or collect it on that basis from a third party. But if the objection is not reasonable, you do not have to accept the objection. Condition 5 is probably not going to be applicable in the medtech world, where this essentially says is if you have to collect the information from the data subject, it will actually jeopardize the lawful purpose of collection. And then the last option is that it's not reasonably practicable in the circumstances to collect it directly from the data subject. So hence again, in the analysis in your business, you need to say, where do you collect information from and which of these grounds is actually applicable, supporting that collection from that source to make it lawful. Then I want to mention the data subject's right to know, and this relates to the transparency under POPIA and also the reasonableness of processing. So there are a number of things that you have to communicate to all your data subjects. First of all, you must communicate your details as a responsible party, and obviously if they don't know that you are collecting their information. Secondly, you must communicate to them what is the nature of the information that you collect. If they have to provide information or you request information, you must tell them it's voluntary or mandatory, and if they don't provide the information, if it's mandatory, what will be the consequences? You must tell them the source of collection. So where do you get the information from? For example, if you use MedPages to collect information from healthcare practitioners, then you actually have to identify the source. You must tell them, why are you collecting that information? What is the purpose? And is there a law that authorizes that collection? You must also tell them whether you are going to send that information across the borders of South Africa and what is the protection, the level of protection in that other country. You must be able to tell them with whom have you shared their information, who were the recipients. So you must be able to record that in your business. And you must also tell them about their rights, that they can request access to the information, they can object if there's a legitimate purpose, basis in place, they can ask you for a correction or a deletion of information, and you must even tell them that they can lodge a complaint at the information regulator. Now, the law does allow you to sometimes dispose of these requirements where you don't have to communicate. For example, if you are going to use the information for historical, statistical, or research purposes, then you don't have to communicate this. My advice to you is, as far as possible, do communicate this information because it impacts on an assessment of your reasonability in the processing. So the question is, when do you communicate and how? The when is before you collect information, if it's possible. If it's not, as soon as possible after the collection. And how should you communicate this? This would depend on the type of data subject and your business. So, for example, a privacy policy will go a long way in communicating this information, but you may also use other mechanisms. For your employees, you may create, for example, a specific document. Or when you recruit people for job applicants, you can have a specific document. For your healthcare practitioner clients, you can use your privacy policy, or you can create a specific document or use it in terms of contracts that you conclude or with contracts that you conclude with these people. So that's in a nutshell that I want to share with you. I'm going to just high level tell you about privacy breaches or privacy breaches, and then I want to focus on the questions that I have received. So just to give you a sense of what is attracting fines at the moment in Europe, and let me assure you, there are many more than this. I've seen a report in the last week that we're seeing that they, at the moment, calculate that there are 600 privacy breaches per minute worldwide currently happening. So you can imagine regulators across the world have a lot of work to do. The first case is where a person has, and this is an individual, sent emails to 130 recipients but didn't blind copy them. They were CC'd, and that was regarded as a transgression of privacy. The second case is access to information, so you must make sure who has got access. Do they need access? In this case, it was a high-profile person. 85 employees had access to that information. Storage of records, where files were not stored properly, or login credentials were found in public storage areas. The credentials or the file got misplaced. The minimality principle, where companies are actually collecting more information than they need for their businesses. We're seeing different cases coming through and penalties being imposed. Access to personal information, where a company tried to actually restrict the number of times a person could come and ask for access and placing limits. The regulator said you can't. It's essentially a person can come and ask as many times as they want to for access. Record keeping, a few cases coming through where companies don't have record keeping policies, they're keeping information longer than needed, all attracting actually penalties. And then be careful with marketing. I haven't dealt with marketing this morning, but unsolicited electronic marketing essentially needs consent. There are certain extra provisions with your customers, but in this particular case where people downloaded an app, information was sent to them, but there was also marketing content included, and that attracted a penalty because there was no consent. So just be careful in terms of communication. In a nutshell, to become POPIA compliant, you have to consider your information officer and deputy and register your information officer. You need to identify all the lawful basis of processing, further processing, collection from third parties, and when you send information across the borders, you need to have a POPIA manual in place. You need to look at policies such as a privacy policy and a record-keeping policy. Make sure you don't keep records longer than authorized. Make sure you have notifications to data subjects. Review all your documents to see whether they are aligned with POPIA. Collect and process only what you require for a lawful purpose. Review your outsourcing agreements. Make sure that everybody acts under confidentiality obligations, employees and other people providing support services. Implement all the processes. There are 5 to 6 processes prescribed under POPIA that you have to implement. Make sure that your record storage is secure. I don't have the time this morning to speak about automated decision making, but if you do profiling, look at the requirements in POPIA. POPIA also has requirements if you have public directories. It talks about consent for marketing purposes. Consider to whom you disclose information, whether that's lawful. Look at your security of your systems and processes. Look at enhancements of system functionality if you need that. There's certain notifications to the regulator, which we covered this morning, the prior authorization. Make sure that your employees can navigate the law, guide them and train them. And do consider insurance. It's not a requirement, but it's something that I think one should apply your mind to, although it is very expensive at the moment. So with that, let me turn to the questions. So the first question I had, and I'm just going to summarize that, you can look at it in your own time, is it relates to how long you should keep records for. Because healthcare providers only keep records at their business, their requirements for 5 years, and they can go out of business 5 years after the lifespan of the device. And a product recall can come much longer. So how long do you keep records? Now, the medical device regulation says your Class D implantable device, custom-made medical device, 50 years. But remember, there are other devices as well, and you have other options under POPI. So I've given you those options. So you can go and look at those options and you keep the records according to those options, but define your reason for keeping it longer. So your minimum period will be what the legislation requires, but you can keep it longer. The second question was about whether hospitals can function without patient names and only identify them by numbers. My understanding is that they, in terms of invoices and quotes, they don't want patient names any longer included on these documents. Now, I'm not exactly sure how the hospitals run their own processes and systems. I can say, though, that it's not a POPI requirement to omit patient names. That's definitely not required. It will depend on the context. And if they do omit patient names, there is obviously the risk still in terms of errors. And the hospitals need to be vigilant around patient safety and patient interest. So I'm not sure why they are doing away with patient names, but it obviously, fewer identifiers make the risk less, but they still retain the responsibility to make sure that it gets to the right patient. There was also a request that when patients fund their own devices, for example, they can come directly to you for quotes, but then the device is ordered and sent to the healthcare professional that will administer or implant this. And how will this be affected by POPI? This is absolutely fine. I would just suggest that you do get your patient to consent, that you can then send the information and the device directly to the professional. Consent must be voluntary, specific, and informed, so they must know exactly what you are doing. And remember, consent can also be by email. There can be an email consent. There was also a case where, in this case, where the healthcare provider requests the patient's name on the invoice. What must you do? As I've mentioned, this is not in principle prohibited. So all the POPI principles apply, and the healthcare practitioner must also comply with POPI. So if the healthcare practitioner gets information from you about a patient, they must also be authorized. For example, have patient consent. So you can also request that patient consent. Your device must obviously be delivered for an identifiable patient. So you need to determine how can you identify that patient. You can also consider, for example, what is the mechanism of you transferring that information? Is it a secure mechanism? For example, do you send, because it's healthcare related information, and healthcare information is sensitive information, it's special information. Is the document encrypted? Is it password controlled, for example? So you will need to look at these mechanisms within your business. And also make sure when you send information about a patient to a healthcare practitioner, other than having the lawful right to do so based on patient consent, that you are actually sending it to the correct recipient, that you don't make a mistake and send it to the incorrect person. And then the last two questions related to how the healthcare practitioner's device preferences, where you have this information. May you have it, may you share it with new cell staff. In principle, yes, you still may have it. Just make sure that your source of collection is acceptable in terms of the law. That must be authorized. You must advise the healthcare practitioners if you collect information about them from third parties. You can keep and use it. You apply all the POPI principles, and just if you're going to use it for profiling, look at the provisions around automated decision-making in the law. The last question is about the buying habits of your clients. How should you manage this data going forward? So all the POPI principles apply. So you must, where do you collect it? The source of collection, is that justified? What is your record keeping restrictions? What is the company policy? Do you have a privacy policy or a notification to a data subject? What is your purpose of collection and use? So in principle, you can have it, you can use it, but in the context of the entire law. Let's just end off with a little bit of fun. If you can assist me, Caroline, please. I've got 3 easy polls for you to just answer, and then I think we still have a few minutes for questions. So there's the first question. Which regulator is responsible for the enforcement of POPIA and POPIA? SAPRA, Human Rights Commission, Information Regulator, and the courts. And although the question doesn't state that, let's say which regulator is responsible from the 1st of July. So just make your selection very quickly or very briefly. Okay, so I think most have responded there, and I think most have had it correctly. From the 1st of July, it's the Information Regulator. Currently, POPIA is still under the Human Rights Commission. Next poll, Caroline. So that is on the record keeping.
It is live with me.
Oh, sorry. Now I see it on my screen. Sorry. Thank you. So you've already answered there. Which regulator? Okay. So it's your record keeping periods. So I think there's a bit of a difference of opinion. So this was this a little bit of a red herring or a curveball, but it's actually none of the above. So POPIA doesn't have a particular requirement in terms of health records when it has to be deleted or de-identified. It's actually, you need to look at that from the perspective of POPIA on the different grounds and make your decision based on that, how long you keep the record. And then the last poll, Caroline. Okay, choose the incorrect answer. Just be vigilant there. The incorrect answer: information officers must register with the information regulator, can be held accountable under POPIA and POPIA, have statutory responsibilities, and can be appointed by multinationals at their discretion. And I think most of you have got it right. It's actually the last one. So you don't have that discretion. It is actually a requirement by law. Thank you for participating in that. So my last few comments is just that the intention of POPIA is not to prevent you from doing business, but you must now comply with all the principles. Healthcare industry is a high-risk industry globally in terms of data breaches, so we have to be vigilant. Compliance with POPIA starts at the top. If management doesn't buy into this, it will not filter down in the business. It has to become an integral part of your business because of the seriousness of the potential sanctions and the sanctions for information officers. And remember that any weak link in your organization exposes the entire organization to risk. And yes, time is actually running out. I think when we probably speak again, the law would have eventually been implemented. I think there may be a few minutes left, Rob. I don't know if there's time for questions. I have not been able to follow the chat. So if there's a specific question there, I would appreciate if somebody can just raise that with me.
Thanks, we've got a minute. There was is POPIA in all languages. There was an answer. First is a manual talking about it has to be in all languages. And you know, I know that you provided some guidance in terms of POPIA manuals and so on. But the answer is, as I understand it, your POPIA manual has to be in all languages with 2 copies in office of 2 official languages. Am I correct there?
That is only if the draft regulations are going to become law. So I have to put it up so that you are aware of it, that there is a risk that that's going to come our way. I think at minimum, we're probably going to end up with at least 2 official languages for our POPIA manuals, and not hopefully all official languages. I am concerned about the practical execution of that and the cost. So just watch the space. I'm sure SAMET will keep you informed when the legislation is final and what the provisions state.
Thank you. What if a multinational, or as a multinational, you have a data protection team outside of the country? Is the requirement for a deputy information officer an absolute requirement?
Well, it's not a requirement in the law, but the regulator has now actually stated that as a requirement, that you have to have an information officer and a deputy in South Africa. So the question is, I don't know how the information officer or the regulator is going to respond if you don't do that. So, and you also don't want to, at this point, get onto the radar screen of the regulator. So in my view, you can probably challenge them in terms of the law, but the question is, do you really want to do it at this point? And put yourself there right in, draw the attention of the regulator. But it's a regulator notice, and it's not a requirement of POPIA.
Okay. Is there a link to download the information officer registration form? I think, Carmen, you've provided that. That's fine. Kirsten then asked, with regard to record retention, in terms of the Companies Act, your record retention period is 7 years, in some cases 10, 5, whatever it is. But I think you did indicate that whatever law applies would be the term for record keeping.
Can I just maybe say again, Rob, so the law is your minimum. That's your minimum requirement. If there's a law that specifies that. If you need it for another lawful purpose, you can keep it longer, but just justify it and state why you keep it for a longer period.
Correct. Ismail, thank you very much. I think it's been an extremely informative and important discussion that we've had. Guys, please, we'd like your feedback on the session. Caroline did post the link to provide the feedback, both for this and the upcoming session. One thing that I just want to sort of close on, which is quite disturbing, is in terms of the case study where people don't blind copy a recipient list. I mean, this is really a major concern, because it's just a sleight of hand, and people quite often do that unintentionally. They just maybe don't know how to, or they do it by mistake, or whatever the case might be. So are you saying that, for example, the person's email address is protected under POPIA? And if I, just as way of an example to conclude, if I approach SAMET and say, I'd like the name of the CEO of company ABC and his email address, can you give it to me? What is the situation there?
Okay, so first of all, Rob, yes, an email address is definitely personal information. Secondly, I think one also needs to look what is necessary within a business environment. For example, if you have in your company and you invite people to meetings, it's an internal meeting, people need to know who's in the meeting. So I don't think that's a problem. It's when you communicate externally to external people. And your question in terms of you ask that information, certain of that information is like for what you now mention is authorized in the POPIA law. So that can be provided. But yeah, one must always look at the context. And that's why the reason why I used that case study, because it attracted a fine for an individual in Europe. And I think our regulator is going to follow probably the examples in Europe.
Very much so. All right, Esme, we'll let you go. Thank you again. I think it's been extremely useful and valuable. Thank you so much. Thanks
to everybody, and goodbye.
Thank you. Right, now we look at what is the latest in competition law, and we are going to do an overview and update on competition law with a specific look at the healthcare sector. and that'll be presented, or Heather Irvine is here to speak to us. She's a partner with Bowman's in Johannesburg's Office of Corporate Department, and a member of the competition practice. She has a competition law certificate from the University of Wits and has been an external examiner in undergraduate and master's competition law courses in that university for the past 5 years. Heather has also been instrumental in assisting SAMED in engaging with the Competition Commission in terms of ensuring that our code is compliant in respect of competition law, and we've had a very pleasant engagement in that respect, and Heather's well versed in the world of competition law. Without further ado, Heather, welcome again, and over to you.
Thanks, Rob. Good morning, everybody. Thanks for dialing in, and hope that I can provide some insights, and there's plenty of time for questions. So if anybody would like to put a question into the chat box, if you're shy, or to put on your camera and raise your hand, I'm happy to take some questions as we go along. There have been a limited number of competition developments which I think are of relevance to SAMED and members since we last spoke, because we've been through a slightly weird period in competition law, as with everything else, I guess, that the Commission has been very heavily focused on these pandemic-related excessive pricing cases. And this has meant that a lot of the Commission's other work has been delayed or put on hold. And we've seen an enormous amount of focus on trying to stop people from pricing excessively on PPE and basic foodstuffs, and not a lot of action in other respects. But I think it's worth bearing in mind that the Competition Commission is still a very active and independent body. They will undoubtedly get back to their knitting, their core jobs, which is really to make sure that companies don't collude with their competitors and they don't abuse their dominance. And then in addition, there have been some amendments to competition law, which only came into effect late last year. And I think they're going to significantly change the competition landscape, and all of us are still feeling our way around some of those changes. So I'll talk a little bit about those.
Would you mind just putting your presentation or your slides on presentation mode?
Oh, sure. Sorry about that. Thanks,
Thank
Rob.
you. Thanks.
Can you see them now?
Not yet on presentation mode.
How about now? Have they popped up in full screen?
No, they have not, Heather. I can also share from my side if you're struggling.
I'm going to try one more time. How about now?
It's not listening to you, Heather.
Not listening to me. You see, I'm a legal expert, not an IT expert. I don't really know what to do about that.
Heather,
Yeah.
go right to the top where you see what to save, and then it's off, and then it's the save button, and then the next one should be a button that looks like I can't see a screen anymore.
Yeah, I thought I'd just try again
and
see if it works this time. How about now?
Nope.
Oh dear, it's coming out in full screen on my side, so I'm not too sure what to do about that.
I think let's just proceed in the format that you have it now here. It's not too bad. I mean, we can manage. Thanks.
You can make it out, right?
Yeah.
Best I can do is shrink it for you like that. Sorry. So what I was saying is I'll talk a little bit about these cases that we've seen during COVID. Then I'm going to talk a little bit about the amendments and how those will change the landscape. And then finally, I thought I would just talk a little bit about this impact study that the Commission recently did on these exemptions, which were provided during the pandemic period, which have allowed an unprecedented amount of collaboration in the healthcare sector in order to deal with the pandemic. Because I think that may well change the way that the Commission views competitor collaboration in the healthcare sector. So the big amendments we've seen so far are these protections from price discrimination, and also new rules which stop dominant buyers in designated industries from abusing their dominance. Just to note that healthcare is not a designated industry. So at the moment, that's not necessarily something that you need to worry about if you're a very big company buying in supplies. But of course, the minister can add to these industries, and I have a feeling that he's going to do so in the healthcare sector, because I think he's conscious that this problem of big buyers squeezing little suppliers might well be something that's playing out in the healthcare sector as well. And I suppose if the shoe's on the other foot for you, if you are a small supplier that is finding that you are being consistently squeezed and big buyers are imposing unreasonable pricing or unfair terms and conditions on you, you should consider writing to Minister Patel to indicate that you think your industry or potentially just your particular segment of the industry ought to be designated under these new rules, because that would allow the Commission to extend much greater protection to you. So these amendments to the Act really have come into effect in order to make it easier for the Competition Commission to sustain complaints. There's now a reverse onus on the dominant firm. So previously, the Commission bore the burden of showing that a company had contravened the Act and that they were dominant. Now the shoe's on the other foot. Once you're shown to be dominant and there's a prima facie evidence that you've engaged in this kind of conduct, you then have to show that your pricing was reasonable or that you didn't engage in price discrimination. So that's a very significant change. And it remains to be seen whether that will shift the landscape significantly so that we see a lot more abuse of dominance prosecutions. Then there's been a tweak to the sort of general catch-all provision that says you can't, if you're a dominant firm, engage in an exclusionary act. Previously, that was defined as preventing a customer or competitor from entering into a market or expanding within the market. But now it also includes doing anything that prevents your competitor or your customer from participating in a market. That's a much lower hurdle to cross. It could be, for example, that your discounts or rebates make it impossible for your competitors to make a go of it. And that would be enough, I think, to be able to establish that contravention. And then lastly, there's a whole lot of additional factors that have been put in the Act which can indicate that there has been excessive pricing. So it's not limited to only assessing what is your margin. It could be a whole host of factors like what are the prices in comparative markets and various other kinds of economic modeling that could be done, which could help you to demonstrate, if you brought a complaint, that you are paying an excessive price. So as I said, the Commission has investigated a huge number of these complaints about excessive pricing since the state of emergency was declared. You may remember that in March last year, Minister Patel put out these special regulations, which effectively said that if your price had jumped within a 3-month period by more than your margin over the previous 3 months period, you would be presumed to be pricing excessively unless you could show that your new price was actually related to an increase in costs. And this caught a large number of companies unaware. Some suppliers of things like sanitizers and gloves and various other kinds of PPE had not appreciated that they could not simply start pricing up to the market price just because they could. Or some people had started putting in price increases in anticipation of their input costs going up. There have been at least 2 challenges that have gone to the tribunal on this, and the tribunal has given very short shrift to these companies and has imposed fines in both cases. They've said unless you can clearly demonstrate, if you're selling an essential good or service, that your increase is directly related to the increase in costs, you cannot simply price up to the market price. And we were taken by surprise because even a couple of very small companies, firms that you would never normally have thought were dominant, were held to be dominant simply because they had been able to increase their prices by a substantial amount in a very short space of time. It's a slightly circular argument, I think, to say, well, you must be dominant if you can increase your price substantially, because really whether you can increase your price substantially may simply be a temporary phenomenon in the market. It doesn't necessarily, to my mind, indicate that you are actually dominant. It may simply be that the market hasn't caught up with you. And whilst there may have been a period of time, I think, where people could not travel, you couldn't go around and shop around for masks or sanitizer because there was a hard lockdown. That's not something which is really applied to life in South Africa for a very long time now. So it does appear to me that the Commission has taken a hard line on this in the hope of making examples of a couple of small companies imposing very high fines, and then hoping that that would deter most people from pushing through massive price increases on basic goods and PPE. And I do think that they've been largely successful in their efforts. This really has caused a lot of people to pause and think carefully about how they price. And there's no doubt, I think, that these cases, although they happen in the specific context of the pandemic and they're very fact dependent, I think that they do open the door for future complaints about excessive pricing, because we now have this kind of concept that's embedded in our law that says that excessive pricing can actually be a temporary phenomenon. You don't have to be dominant over a number of years or even months, and it might not be linked at all to your market share. So not only firms who've got a market share of 35% are going to be considered dominant firms. It could be a kind of temporary dominance that arises in relation to some sort of specific factual circumstances. And then you have to be very careful about how you price and make sure that your price increases can be linked back at the end of the day to some sort of increase in costs. It's not good enough simply to show that everybody else in the market was charging similar prices if you can't link it back to costs. And just a reminder that these excessive pricing restrictions are still in effect. They remain in effect for so long as the lockdown carries on, although of course we're now at a significantly reduced level. Rob, I'm going to move on to talking a little bit about price discrimination. I don't know if there were any questions about excessive pricing in these COVID cases.
Nothing at this time.
Okay, great. Okay, so price discrimination is another part of the Competition Act, which has been significantly amended at the end of last year. You might remember that previously dominant firms were prohibited from charging their customers different prices if the price difference distorted competition between the customers in the customer's market. So we've seen very few of these cases, only one prosecution to date, and that was a prosecution involving Sasol, which was eventually dismissed because the Competition Appeal Court said, look, at the end of the day, even if Sasol did charge the small customer a price which was higher than the much bigger buyers, this was probably related to a volume discount. It was based on cost. And even if the little guy exited, the chances are it wouldn't actually harm competition in his market. Excuse me. So this has created a lot of unhappiness. Sorry, excuse me. Sorry.
Let's just give Heather a moment. It happens. The wrong tube.
So sorry about that, everybody. I've got a frog in my throat.
No problem.
Right. Let's try one more time. So we've seen some of these amendments to Section 9 of the Act, and they are specifically aimed at eliminating discounts which are harmful to small and medium enterprises or firms that are owned and controlled by historically disadvantaged persons. And important to remember there that volume discounts are given purely because you buy a lot is no longer allowed per se. Excuse me. Okay, so in summary, if you're a dominant firm, a company which has a market share of more than 35%,
or you suddenly find yourself in a position of market power, there are a couple of absolute no-nos that you need to be careful of. Firstly, long-term or exclusive supply agreements. The Commission is totally allergic to these, and although they are actually not totally unlawful under the Competition Act, they don't like them, and they won't allow them in practice unless you can demonstrate that they're absolutely necessary. So any exclusive agreement which lasts for longer than 3 years potentially puts you and the other counterparty to that agreement at significant risk. Then offering discounts to very large customers on key inputs, which are much better than the prices you offer to SMME buyers or purchasers who are BEEE firms. You do need to think a little bit about the impact of your pricing on your customers and whether potentially the prices that you're offering to your best customers are making it absolutely impossible for their little rivals to be able to eke out a living and remain participating in that customer market, which is, of course, not an easy thing to do always, because you may not always have a sense of what exactly someone is doing with your products and how much it really matters to them if there's a price difference. But if you are in the world that you're supplying small firms, the tail of your buyers, with products that are absolutely critical to their survival, and you have currently got a system of price differences, you do need to look at that and consider whether those price differences are justifiable. And there are, of course, still several grounds in the Act which you can rely on. And then lastly, excessive pricing. You need to be very careful about sudden price increases, which are not directly related to an increase in costs. And the key here, I think, is that you have to have some sort of a system for monitoring your pricing. Even if a relatively junior sales executive suddenly pumps up the prices in a branch office that isn't your head office, that can potentially expose your company to a complaint. And you definitely don't want that to happen. The only way to deal with that is to make sure that you understand how your sales team is actually out there pricing your products on a daily basis, and pick up any sharp increases and understand what the reason is for them before they're actually put through. Rob, I'm going to talk a little bit about competitors now. I don't know whether anyone's got any.
Good, Heather. I'd just like to come in and just ask a question. You know, in terms of exclusive arrangements, looking at it from another perspective or aspect, and this may be a sort of a nonsense question, but if I have an exclusive arrangement with my international supplier to provide product into this market, is there a chance or a likelihood that a HDP may challenge that and say, I also want to distribute that product in this market? Would that find gravitas with our commission?
Rob, it might. So that person that goes along to complain would have to show that there is an anti-competitive effect arising from the exclusive arrangement. So they'd have to show, for example, that they can't get a similar product and distribute it for anyone else in South Africa, or that there's no kind of alternative products available to them which are different, but which would still allow them to be able to participate in the distribution market. So I think that limits the number of markets in which that kind of complaint really would have any traction. And then secondly, you've always got the opportunity to justify some measure of exclusivity if it really is important. So if you've been given the exclusive right to distribute a product because, for example, you need to make investments, it's a highly technical product, you need to train your teams and understand it in order to be able to market it, and there are safety concerns, or it's a very high-tech product, then obviously the Commission will be understanding of the fact that you can't make that investment and then on the next day have some rival come in and start eating your lunch. There's got to be a reasonable period of time which allows you to recoup your investment. So typically the Commission will allow exclusivity of between 3 and 5 years in most markets. So as long as there are other upstream suppliers and lots of other distributors and similar products, chances are exclusivity of between 3 and 5 years will be okay.
Thank you.
Okay, then just to talk briefly about cartels, this is obviously remains a big focus for the Competition Commission, and the Commission has still got this corporate leniency policy in effect, which allows a competitor that's actually been involved in a price fixing event or has engaged in an agreement to divide markets or has rigged a tender to go to the Competition Commission and give them all the information in exchange for complete immunity from prosecution under the Competition Act. So this has been a very effective weapon for the Commission. They have historically got a lot of cartel cases with assistance from someone who is actually inside the cartel. And so one does need to be aware that this part of the Commission's enforcement role has certainly not gone away. There are some quite simple rules for competitors, which I think some of you probably heard from me before. But in summary, you do need to make independent decisions on what prices to charge, what terms and conditions you offer, which customers you service, which geographic areas you trade in, and which tenders you bid on or don't bid on. You can't agree on any prices or trading conditions with competitors, and you can't agree to divide up markets by customers or by geographies. And you can't do anything that rigs a tender. And there, of course, particularly if you're participating in any kind of tender to the state, you're at risk because Treasury is monitoring those quite carefully and does from time to time send information to the Commission if they think that there has been collusion. And the Commission is very quick to prosecute those cases. Of course, it's true that when you sit around the table with your competitors, you may be there for a totally legitimate purpose. So you may be engaged, for example, in a SARMED meeting where there is all sorts of legitimate discussion going on about a range of things. And somebody just makes a mistake. They start talking, for example, about the pricing that they're receiving from a supplier, or they're getting squeezed by a customer, and these are the terms and conditions. That happens often, and as long as it stops right there, there's no suggestion that you've entered into an agreement or an understanding simply because someone's passed a comment. But it is important to immediately stop the discussion. So if necessary, you should object and indicate that the discussion is, in your opinion, potentially a problem, and it should not go any further until you've taken some advice. And the SARMED people, I think, are now well versed in dealing with those issues as and when they come up, but certainly don't stay in any meeting or in any phone call where there is a discussion which looks like it may end up in price fixing or market allocation or something which resembles collusive tendering. It is important to tell SARMED if this happens so that it can be dealt with properly. And lastly, my standard reminder is please remember that the people in Pretoria are very keen on phoning people up and asking them lots of questions. And you should under no circumstances communicate with the Commission by way of a telephone call. You should always say to them, we're happy to cooperate and assist you. Please put your email into my email box and I'll make sure that it goes to the right people. And then we can understand what exactly is the Commission asking, why are they asking it? And if you do send a response, you can make sure that you put in a confidentiality claim and ensure that any information that goes to the Commission is maintained by them on a confidential basis. There's sometimes confusion that arises, in particular when competitors are supplying each other. Now, this happens often, and there's absolutely no reason why, if your competitor phones you and says, can we please have a quote? We want to buy your products. There's no problem with you providing a quote which sets out what your pricing is or what your terms and conditions are. You should, however, be very careful that that normal discussion about buying and selling doesn't morph into something which is actually an anti-competitive agreement. So, for example, you can't say, well, I'll sell you these products, but you must agree not to supply them to my customers, or you can only sell them in Gauteng, or I'll sell them to you, but you must make sure not to undercut me by more than 10%. Any of those kinds of additional restrictions would undoubtedly be seen by the Commission as a form of price fixing or market allocation between competitors, even though you find yourself in a buying and selling relationship. You can, of course, have a discussion with your competitor if you're buying from them or if you're selling to them about what your terms are, what the technical specs of the product are. You can supply them with all the necessary documentation which supports the product that you're selling. But you can't start allowing them, through dealing with you as a customer, to have insight into the rest of your business. So if they say, well, tell us what you are charging other competitors in the market, your answer should be, I can't do that because that would amount to an anti-competitive sharing of information. So it's really got to be in the context of your buying and selling relationship, and you have to think carefully about which hat you are wearing when you have discussions with your competitors in the buying and the selling context. And then just to note, the Commission is still concerned about exchanges of competitively sensitive information by competitors. They expect you not to discuss anything with your competitor that isn't already in the public domain, and you can't discuss anything which is competitively sensitive. And the Commission has published a very extensive guideline on this. I think I've probably talked to you in some detail about it before, but it's on the Commission's website, and it's definitely worth a read if you've got any doubts. But in essence, what they say is if an organization like SAMED wants to collect up statistics, for example, if you get asked for these by a government department, or you're participating in some sort of initiative like a Business for South Africa type initiative, you can collect information, but you have to make sure that if there is competitively sensitive information being given in by competitors, that goes into a black box. SAMED would have to effectively create the black box and then only publish it in an aggregated way. In other words, it must be averaged out over a period of time, which is at least 6 months, and it must be aggregated data for at least 5 competitors. And it certainly must be historic or potentially current, so no later than 6 months, and it should not be predictive. So it shouldn't say what we're intending to charge in the coming period is. It should only be what these 5 competitors, or preferably more, have charged on average over the past period was as follows. And then any talk of pricing, particularly if it's looking forward, is always regarded as problematic by the Commission and should definitely be avoided wherever possible. Okay, Rob, I don't know if there's any question about the sort of general principles. I'm just going to talk a little bit about this healthcare exemption and the study that the Commission did on that.
Now you can proceed, Ed.
Okay, great. So you might remember that there was this block exemption, which was actually obtained by the hospitals, but was subsequently extended to a whole range of manufacturers and suppliers of all sorts of PPE and related products and consumables which were necessary during the pandemic period. And interestingly enough, the Commission has gone and done a study, which is on their website, and I'll circulate it because I think it makes for quite interesting reading. They are trying to work out to what extent companies in the healthcare sector actually use this exemption, and has it been successful in allowing competitors to collaborate in order to combat the virus. So interestingly enough, the Commission identifies a number of instances where people actually have told the Commission that they did use the exemption. They did in fact fix prices or divide up markets in order to facilitate supply of these goods during the pandemic. So there was a lot of procurement type coordination on PPE, which the Commission says did actually lead to lower PPE prices, and also made sure that there were adequate supplies. There was at least one medical scheme administrator, which administers more than 10 medical aid schemes, who collaborated with a wholesaler of healthcare products in order to get that PPE to the healthcare providers. So normally, hospitals that are competitors wouldn't be allowed to collaborate with each other on fixing purchase prices to buy inputs. But using this exemption, it seems that they were able to do that, and it was done by means of the intervention of the administrator. And then they noted that there have been a number of agreements and practices between funders and healthcare facilities, which have reduced the cost of diagnosis and testing, and various other kinds of preventative measures related to COVID-19. And lastly, that there had been discussions through the Healthcare Funders Association about pricing and billing codes, which had enabled them to reduce the cost of diagnosis and treatment over the COVID-19 period. So the impact study concludes that the healthcare exemptions in the context of COVID-19 were in fact a big success. They did achieve their intended effect, and they reckon that they actually managed to reduce the cost of COVID tests substantially, which saved patients and medical schemes over 1.5 billion in the year. I think the study ended in October 2020. So this is, I think, quite interesting since the Commission has historically been so reluctant to grant exemptions in the healthcare sector, we have seen a few, but in general, the Commission says what matters to us is competition, competitors must compete, and even if you can show that price fixing is efficient or would serve a sort of broader welfare goal, we're not going to allow you to do it. This, I think, is an experience which will make the Commission think a little bit. I think they might well see that there can be some positive effects in funders, administrators, hospital groups, and suppliers coordinating more on pricing, which could actually lower prices and be good for patients. So there is a provision in the amended Act which provides for wider grounds for exemption. And I think in future, the Commission might be more receptive to those applications for exemption based on this experience, which proves that collaboration between competitors can actually be a good thing as opposed to a negative, which can almost never be justified. So I think that's something interesting to bear in mind. If there are particular collaborations which are necessary for SARMED and its members, which go beyond the existing collaboration on the code, for example, that's certainly something which I think you might get a slightly better reception in Pretoria than what you've managed to date. That's it from me. Any other questions, Rob?
Yeah, I don't have any questions in the chat. Just by way of sort of supporting some of your comments, you know, in terms of the customer-competitor relationship, there, you know, one has to be very careful about that. And I have personal experience of that. When in the old days I was manufacturing syringes and needles, I supplied a distributor who in turn then decided to compete with me with an imported product on the state tender. And I then terminated our relationship and did in fact appear before the Competition Commission and had my knuckles duly wrapped and told, you will supply this man with your product as you have in the past. So yeah, it's a very, very real factor there. I do see a hand. Let me just see if I can pick it up. Donato, please go ahead.
Hi, Rob. Hi, Heather. Thank you. I just have one question. I heard you talking about volume-based discounts no longer allowed. Can you elaborate a bit on that point?
Yeah, sure. Hi, Donata. So volume discounts as between customers that are large or not SMMEs or triple E firms are still allowed, as they always have been, based on the fact that usually if you are selling more units, your total cost of production is lower. So the Commission recognizes that that's efficient. So you can continue to have volume discounts which apply to your large customers, people who are not SMEs.
Okay.
But as soon as you give a discount to a large customer, but not to an SMME, so that the SMME's pricing is higher, you can't justify that based purely on volume. You have to then show that it's related either to the place of manufacture or the method of manufacture. So if you're supplying it in, for example, different kinds of packaging, or the way in which you're manufacturing small units for the small customer is just different, you might have a justification there. And of course, there's still justifications like it's an end of range sale, or that you were bringing your pricing to the large competitor down in order to meet a competitor's pricing. But the defenses have shrunk. So it's really, you need to think very carefully about pricing to those little guys. And they are defined with reference to people who've got less than 250 employees. And then there's different turnover thresholds, but in general, somewhere below 100 million rand. You have to look them up by virtue of the industrial codes. Those are the people you need to worry about if they're not getting discounts which are as good as your big customers.
Okay, thank you so much.
Right, are there any further questions for Heather? No, Heather, thanks again. Always a pleasure and always very enlightening and important for us to keep up to date with competition law. It's quite quite onerous, and companies need to adhere to the advice. Please, guys, Caroline has provided the link in the chat for feedback. It helps to guide us for our future events. I'd like to thank both Heather and in her absence, Esme, again for the time to share the valuable lessons that we have had today. If you encounter any challenges in the areas of the POPIA Act or competition law, please, by all means, reach out to the professionals who've informed us of good advice today, and they certainly would be able to assist you if you have any concerns. If you don't have their contact details, they are available through SARMED. It just remains for me to thank you all for attending. I think we had a pretty good, strong turnout today overall, and we look forward to your participation in any of the future forums we hold quite regularly. And thank you to Caroline for organizing. Caroline, I think you're doing a great job in terms of these fora that we attend, and they are incredibly invaluable. Thank you to you all, and have a wonderful day. Bye-bye.
Goodbye.
Thank you. Bye-bye.